Hi, my name is Lori Conroy. I'm an assistant United States attorney. I work for the Department of Justice. And today I'm here to offer some suggestions and what I think are best practices for prosecution of cases involving child abuse. In preparation for a closing argument, just as you did in voir dire, you need to know your jurisdiction's rules on closing arguments. Start with the rules of criminal procedure, any trial memos issued by your court, any standing orders. Ask other attorneys about their experience in front of this particular judge, and ask the court herself what the practice is as far as timing, location in the courtroom, use of technology. I once had a judge who did not want the attorneys to get within a certain distance of the jurors, and he put white athletic tape on the floor as a barrier. I got home after closing one night and realized that I had been walking around with the white tape on my shoe. So I got as close to the boundary and then some as is possible. But the last thing that you want, in all seriousness, is for a judge to interrupt your closing because you have done something that they're not comfortable with. So you should know that going in. You should also know your jurisdiction's case law and rules about things you can say and cannot say in a closing argument. In some jurisdictions, there is a lot of litigation on particular things that are said by prosecutors. And the last thing that you want is to say something in your closing argument that will create post-conviction action and potentially reverse a guilty verdict from trial. Preparation for a closing argument should begin when you begin preparing for trial. Because before you begin preparing for trial, you should know the theme and the theory of your case. You should start developing your theme and theory as early as jury selection. It should be weaved through all of your examinations, and it should come full circle in the closing argument. When you're thinking about your theme and your theory, think about how you want to begin your case in jury selection and opening statement, and come back to it in the closing argument. Throughout the trial, keep a separate notebook and highlight particular quotes from witness statements or particularly compelling pieces of evidence that you want to use in closing. It might seem painstaking, but leave nothing to chance. You want to focus on each of the elements that you are required to prove, and you want to show the jury how you introduced evidence and testimony that prove each of those elements beyond a reasonable doubt. I don't advise that you go through a trial witness by witness in chronological order. There are certain things that you need to cover in a closing argument. Accept the burden of proof, accept the elements of the offense, but do so in a way that tells the whole story. Go from the micro to the macro. Some people like to use a PowerPoint presentation to display the elements and the evidence. And I think in a longer trial, that can be very helpful to the jury because you can show the elements and then you can show particular photographs. You can highlight things that a child says that prove each of those elements. But every case is different. There may be a more narrow case with fewer counts that you feel you don't need a closing argument to do. You can start your closing argument at the beginning of your trial preparation, and you can include the burden of proof and the elements of the offense. But don't write a closing argument and then not change it based upon what happened in trial. As we've already talked about, a child may be different on the stand. Evidence may come in differently, and you want to be sure that your closing reflects the trial that took place in that courtroom and that the jury heard. In a case of child abuse or child sexual abuse, much of the evidence is going to come from that witness themselves, and their credibility is going to be heavily weighed by the jury. You can remind the jury that they are the sole judges of the weight and the credibility of the testimony, but that they don't do that in a vacuum. Use the jury instructions given by the court to show them what they should be considering, and remind the jurors that there is a difference between judging a person's credibility, as in the credibility of their testimony, and judging a person. It is not a jury's role, and I will often remind them of this, to judge a person, to judge their actions, or to impose on a child or the mother or father or other caregiver of the child what you think they should have done in a situation. Their role in judging the evidence presented as against the facts and trying to determine if the government has proved beyond a reasonable doubt what the defendant did is to judge the credibility of what they're saying, not their conduct or who they are as a person. Explain how each jury instruction applies to the case. And this is where you need to know whether the judge is going to be instructing the jury before or after closing, so that you can anticipate. You may even want to get the court's permission to highlight particular instructions that you know that the court is going to give. And as you go through those instructions, apply them to your particular case. One example might be how you consider certain types of evidence. And you'll want to explore with the jury what those types were and what they heard that fit into each of those categories in this particular trial. Address defenses. Don't spend your entire closing argument going down the rabbit hole that may have been created by the defense, but be sure that you do address it in some fashion. It is an important part of the jury's consideration what each of the parties put forth in a closing argument. So whether it's in your affirmative closing or if you have the opportunity to rebut, address what the defense is putting out there for the jury to consider. And if it is something that strays from their consideration of the elements and the jury instructions, bring them back to the considerations that they need to be focusing on. Criminal prosecution can take time. So be sure, as part of your investigation, you ask the law enforcement officers to gather evidence of what a child looked like at the time of their offense and introduce that at the appropriate time during trial, so that you can remind the jury that the person who was in front of them describing the conduct isn't the same person in some respects as the person who disclosed the conduct, because it may be years later. When you introduce that photograph and you talk about the child or the adolescent or the young adult's testimony, remind the jurors how difficult it was for them to talk about sensitive things that had been experienced by them in their lives, and bring them back to that individual on the stand and have them look at their credibility through that lens. Remind the jury that children are not adults and the way that they give information is not the same. And remind the jury that things may not be exactly the same as when they first disclose them. Oftentimes, the defense will want to challenge a witness's credibility by using a statement that they made some time ago versus what they're saying in the trial on the stand. And you may want, in closing argument, if it's appropriate, to remind the jury that even in our own lives, we don't relay things in the same way every time. And in fact, if we did, that might be more suspect than starting at a different point, remembering things differently. And this is where having an expert may be very helpful to your case, to talk during the trial and explain what might be otherwise counterintuitive responses to trauma, and how memory, sensory memory, may be different than remembering what someone said. And be sure that you bring all of that around to the jury when they are considering the child witness, the child survivor, and their testimony. In cases of child abuse and child sexual abuse, you likely have medical professionals who engaged in some sort of examination with a child. And you may not, depending on the historical nature of the disclosure. But in cases where a child was subject to a sexual assault examination, I call that nurse to testify at trial, even if there weren't any findings, because it's important for the jury to see what a child went through even after they disclose something very traumatic, that the trauma didn't stop, that even that experience, sometimes by medical professionals of an opposite sex, through something that is embarrassing and invasive, and why It's important to think about that when they're thinking about the credibility of what they disclosed and what they're testifying about. A closing argument is really your last opportunity to talk to the jury about the case itself. Think about if you were to sit across from a friend at a coffee shop and you were going to tell them what a case was. That's the time to be having this conversation. It's not the time to be formulaic. It's not the time to use a lot of legalese. You are talking to lay people about a situation that a child was put in that was a traumatic and difficult experience for them. And you have done your best by the point of closing argument to support and corroborate the disclosures made by that child. You've determined that you can prove this case beyond a reasonable doubt, or you would not have charged it. So put that effort into your closing argument and make sure that when you sit down at the end of the trial that you have put this case together in a way that no juror is questioning what it is about and what the evidence was and how you've met your burden of proof.